One of my specialities, if you like, is wills, trusts, inheritance tax, power of attorney, court of protection. These all might be familiar terms to some of you who are dealing with legal affairs of your own legal affairs or the legal affairs of those perhaps who you care for. If you've made a will, please put your hand up. Keep your hand up if you've made that will within the last 5 years. The reason why I asked those two questions in that order is that hopefully you realise it's a good idea to make a will, but it's an even better idea to keep that will under review. And the reason for that is that people's circumstances change. There are arrivals and departures in the family. Financial circumstances might improve or not improve. So you might dust the will off on New Year's Day 1 year and say, actually, that's not quite right now for where I'm sitting in the family and so on. For those who haven't made a will is a document that allows you to say what happens to your assets after you've died. First of all, you start off by appointing executors. They're the people who have to sort things out after you've gone. I'll come back to executors because often what's in the will informs us as to who the right people might be to actually deal with your wishes. You might want to say in your will if there are any particular gifts, whether that's items or cash sums to go here, there and everywhere. With items, I tend to prefer a technique whereby you put a clause in the will that says you might leave a letter or a list about particular things to go to specific people. And there are 2 or 3 reasons for that. One is that it keeps the arrangement more flexible, so you can change your mind if you fall out with someone or you lose the item in the meantime, what have you, or you give it away, and you don't have to keep changing the will. The second is it's a bit more personal and private. And the third reason is that if you're lucky enough to have things like Georgian candlesticks and grand pianos, if it's in the will, at some point or another this might come across the desk of the Inland Revenue and they might say, well, if you've got Georgian candlesticks, what else have you got? They really focus in on, those sorts of things. So don't flag it up. Don't give the excuse to the Inland Revenue to open things up. So cash sums as well can go in the will. If you have children under 18, one of the important things to think about is guardians. If both perhaps parents have died, they can stand in the parents' shoes and make decisions about schooling, medical decisions, sign the permission slips for school trips, that sort of thing, and generally be legally responsible for the child. Once your child is 18, you can't really appoint a guardian for that person. So they are, if you like, an adult chronologically, and they are dealt with by the social care system or the NHS or whatever part of the state touches them. As a parent, you would want to know that someone that you've perhaps chosen can still speak for them. And I put in, for what it's worth, a clause in the wills to say I appoint Joe Bloggs to be guardian of my son or daughter, and I direct that even though they become 18, they should still be an advocate for them and so on. But the law doesn't as yet recognise that. But it might give some comfort to the family member that you've appointed or the friend you've appointed as an advocate to say, look, I am the chosen person perhaps to speak up for them. Please think about inviting me just to review meetings or whatever. So moving on down through the will, you eventually get to a stage where you've got your assets. Now, you don't list your assets in a will. It's often a mistake people make when they make their own wills, that they try and list down everything they've got. But of course that changes over time, and so that might necessarily not be a good idea. So you just say, perhaps, I leave all my assets to you. If you want to think about a nuclear family, it would go between spouses when one of you dies, and then downward to the children from there. I suppose why we're here today is, if there's an ill or a disabled person that you need to think of in your family, how do I provide for them? The whole thought process about providing for someone who perhaps can't manage money for themselves might be that you would leave what you wanted to leave them in trust. All that a trust is an arrangement whereby you name preferably 2 or more people to sit on some money or an asset on behalf of someone else. The type of trust I'm thinking of is called a discretionary trust, and it means that those people, those trustees, have full flexibility and adaptability over how those assets are used to benefit any of the named beneficiaries in that trust document. In the context of a will, the will be the trust document. It will set all this out. And the reason why trusts are the go-to idea is that disabled person, I mean, typically, my brother was learning disabled, so he might not be able to manage finances, so at least the trustees can manage those assets on his behalf. Secondly, if assets are put in the disabled person's name, it might open them up to financial abuse. My brother could count money, but he wouldn't know the value of money. He might be asked to pay £1,000 for a CD, and he'd happily do it. And the third, but perhaps most important reason, is that the trust funds of that nature aren't taken into account for any means-tested benefits that the disabled person has. That trust fund sort of stands to one side. It's not treated as the disabled person's asset. So it's there as a safety net, as an extra, if you like, for the disabled person. I suppose the most tricky question that families have is, well, how much do I put in that trust fund? And there is no right or wrong answer. So given an example that a family might have 3 children, 1 disabled, 2 not. One school of thought would be that I love all my children equally, they should each have a third each, a third goes into the trust fund and the other 2 have their third when I've gone. The other school of thought might be, well, at the end of the day, the major expenses and care for that disabled family member is going to be borne by the state. And what we can provide as parents is a pot of money that will supplement that might pay for the holidays, or the carer to go on holiday with them, or the expenses to go and pursue their hobbies and things. So it's that extra fund of money for the nicer things in life, or to provide equipment that the state doesn't provide. And these are all questions that can be discussed with your lawyer, or within the family, as to what is the right answer. Moving on down the will a bit, I suppose you could put in a clause, a preference, if you like, about whether you want to be buried or cremated. There you are, that's cheerful, isn't it? Executors have a specific role. They literally jump in, you've died, they get the phone call, you've got to sort out the estate, find out what assets you have, what debts you've got, implement the terms of the will. And they also carry on wearing a different hat as trustees of that trust fund that we talked about. And that's where I said that we'd come back and talk about who would be those executors or trustees. And the normal instinct is to say, well, my other family members, my other children. And there's nothing wrong with that, but there is a bit of an amber light there, because if you're putting children A and B in charge of the trust fund of C, child C, there's a bit of a conflict of interest there, isn't there? Because if they don't spend money on C, it might be that they inherit more money in due course, when perhaps the child dies or what have you. So you've got to play it to see the character of your own children as to whether that's a wise thing to do. So the money's always been with the trustees, but normally what we say is that in most situations like that, if C has died, you pay for their funeral out of the trust fund, because they might not have not money, and then it can go to A and B, the other 2 children. I always encourage people to not only write the will, but a sort of letter, what we call a letter of wishes, which stands next to the will. And if I'm writing the will, it's me whispering into the ears of the trustees, look, I've set up this trust fund. I want you to look after child C. I want you to spend money on their holidays and this, that, and the other. But if they've died, I want the trust fund split up X, Y, Z, in that way. So you've got a sort of blueprint about how it should work. Obviously, if situations do come up where child A and B are total rotters, and perhaps they shouldn't have the money, so it might go to charity instead or something, it might be that for no fault of their own, A and B are in financial difficulties, they're going through divorces. Again, it wouldn't be a good idea to give them the money at that point either. So there are ways of playing about with the trust fund that, you look at the wider family circumstances. We better go and talk about wills that don't have trusts in them. Because you can set up a trust fund now in your lifetime. We've got MENCAP here over there. Now, MENCAP nationally have a corporate trust fund, a MENCAP trust fund. And you can approach them and they will set up a trust fund now, and you put £10 in it and it goes away in a drawer and doesn't do anything until you've died. But in your will, what you'll say is, whatever I need to put in my trust fund for C, it goes to MENCAP to organise. They're the trustees, they sort it out, and they manage it on a sort of not-for-profit basis. So it can be quite economic, particularly for smaller trust funds to do. And it helps out, I suppose, with that question about who the trustees are, because they're independent, they're up there, and would manage the trust fund and how it's spent and so on. But I suppose the advantage of that as well, in the will is much shorter. all I've said is a share of my estate goes to the trust fund set up with MENCAP. You can also set up trust funds without MENCAP. We do it as well. We set up trust funds and there's £10 in it, nothing else to do until someone dies. So that's just a different way of doing it. And the advantage to that within a family, you've probably got parents and uncles and aunts who want to leave money to child C. And if they do that, that's a problem because they inherit money and we're just undoing all our good work that we've done by setting up a trust fund in our will. If we've got a separate trust fund out of your will, they can leave that money instead to that trust fund, if you see what I mean. So you're not sort of setting them up, because it's often the way that grandma leaves money downward to the grandchildren, not thinking about all the problems about losing means-tested benefits, vulnerability to financial abuse, managing money issues for the disabled member of the family. You do need to engage a bit with wider family to say, look, if you're thinking of leaving money to our children, which includes our disabled child, just think that through very carefully and engage them with that discussion. Don't think about death. Think about powers of attorney. They are a method, a document whereby you can name one or more people to deal with a particular aspect of your life. Lasting powers of attorney come in two types. There's the financial one, which is pretty obvious what it does, and then there's the health and welfare one. It's about your personal self, so it's about where you live, what care arrangements you might have, what medical decisions you might have, and that can include, if you tick the right box, end-of-life decisions. Signing a power of attorney, you've got to understand what you are doing, and there is no rhyme or reason or rule of thumb except to say you've got to start off assuming that they do have capacity. But if they become aware really that they're not understanding the conversation, they're not following the flow of the conversation or what the nature and the purpose of the document is, we might then get a specific doctor's report on their abilities. But sadly, of course, there are some who might obviously not be able to understand anything. So for any of us, really, to have a power of attorney in the back drawer somewhere, just in case, of an accident or an illness, whatever it might be, someone can step in and sort things out without necessarily involving courts and this, that and the other. No, there's no automatic transfer of anything of that nature. The powers that you delegate have to be delegated. If you don't have a power of attorney, what happens then is someone applies to the Court of Protection, that's a real thing, to become appointed a deputy. And basically the same job as a power of attorney, except you're quite closely supervised by the courts. Every year you have to put in an account as to what monies have come in, what monies have gone out, and you can sign on the bank accounts for them. It's all free and easy and online. Like anything in life, you can download the forms. Will they necessarily point up questions or have the ability to discuss matters with someone who's been down that road several times? You've got to be wary that the Office of the Public Guardian, which is a real body, like the Fat Controller, is the registration body. And if you put things in the wrong boxes, they will reject it. Where people trip up is there's two particular boxes called preferences and instructions, and people try to get carried away and say, oh well, I want the money to go to my son every month of £1,000 or whatever, and the OPG won't like that because it looks like a gift, and they don't like attorneys being empowered to make gifts without the court authorities. I think if you're looking through a directory of people to, how do I choose a solicitor if I haven't used one recently, it would be to look for that they're members of Solicitors for the Elderly, who have the right skill set and knowledge, or STEP, Society for Trust and Estate Practitioners. But Solicitors for the Elderly particularly, you can't just sign up to be members of these, you have to sort of pass through a threshold of quality, if you like, and they're usually specialists. So.